First one here, I love it. This is like holding what's it called? No holds bar.
Yeah.
At the right, here we go. Right to the gut shot. Can a patent attorney steal your idea before they help you patent it?
Sure, why not?
The answer is yes. Let's move on. Let's just move on. The answer is yes, and you wonder why it lives so well. No, the truth is yes, but it would be the worst decision of that attorney's life. They have built up their entire career, gone to what, 8 years of school, maybe more with undergrad and any graduate degrees.
Hundreds of thousands of dollars worth of debt.
Dedicated your career to it. Bottom line is there's no opportunity big enough. It's just, what are you doing? You'd have to be such a darn fool. And that's why you take an oath. That's why you swear an oath to the public, to inventors, on top of the state oath that the attorneys take to obviously, duty of care, duty of loyalty to clients. The patent office makes you basically do the same thing all over. Trademark attorneys, have their state law oath and other, it's about integrity. It's about trusting. And oftentimes attorneys are the first line. You have to be able to trust someone, another human being, with whatever good, bad, ugly, exciting news you have. And on the patent and trademark side, it's usually good, fun, exciting news.
Sure.
To move forward and protect something, you do have to take that leap of faith and trust somebody. So I don't want to take this question totally as a farce. I mean, it is something that comes up. I know a lot of clients have considered, like, gosh, what do I do? I have to trust someone. So I would say do your research. Like if you're going to go have a serious decision about anything, if you're going to go hire a wedding planner, I mean, if you're going to go hire, a CPA, or you're going to go look them up. Who is the individual? Who's the founder? What's the company? How do they work? Testimonials. Look at the reviews. Talk to someone else. See if they're legit. Those are all things that you can do to kind of help maybe mitigate that risk against that individual or the law firm itself. You can go look at the state bar. That is probably the number one way to sort of verify, validate the attorney, make sure they're not under current, whether disbarment or if they're currently suspended. They're going to see all their disciplinary issues can come up. It happens to a lot of people. And do your research. Anything else you would add to that, Matt?
No. I mean, I can't think of any trademark examples where, at least I've I'm sure it's happened, but I can't think of any where an attorney has stolen a client's IP, right?
Yeah.
The only thing I could consider where an attorney might own some of the IP is in the rare, not not recommended situation where the attorney, in lieu of payment, takes partial ownership of the company. Yeah. That's a whole other can of worms, and we obviously don't do that here.
No, we don't. I have heard of that being done. It's like anything else. You have like the repo man. Yep. Right? If you're buying a car, that collateral is the car. Right? If you don't pay your loan to the bank, you could have someone put a boot on it or drive it off. I've never had that happen to me, but it happens. They can reclaim the asset. Now with patents, it's a service, and so it's a bit trickier. You can't just go take the brain of the inventor. But when you have a filing, an actual definitive documented application or even a granted patent, now you have an asset. And if they have a bunch of money they owe you, they haven't paid you for your legal services, some attorneys use that as collateral. We don't, but I think that would wait. I don't think the word is steal. I think that's too severe of a word, but you're right. That is an interesting way to do it. We haven't done that. We don't deal with that. We don't, we do our best up front to screen our clients and make sure that they are a good fit. And we don't take everybody on. If somebody seems a little bit too wily, want to put a lot on credit, or they're just not, financially secure enough, they're not going to be a good fit. And that doesn't end up being the problem. One other way I think that this could come up, that probably wasn't even part of the original question, is equity. So sometimes attorneys work for equity. It's usually in terms of a business. So if the invention, the patent, an IP, and trademark is owned by the individual at first, then they assign it to a company that they own and manage. And instead of getting paid money for legal services, the attorney can negotiate a percentage of ownership in that company. it's a little different, but I suppose there could be a situation where big breakup, right? And as part of that dissolution of the company, well, the attorney is going to want to get paid and they want to get their share of equity. And part of that could be from the proceeds of a sale of the IP. And again, that's an extreme.